We left off with why do I need a will?
Any competent adult needs to have a will.
What do you mean by competent?
Sorry, got to start over. I shouldn't
Yeah,
say
that's
that.
okay. So, what are the considerations if I'm buying or selling a business? Should I think about?
First thing is, if your business is a corporation, you might want to, if you're on the seller side, very often it's advantageous to sell the shares of the business to a buyer and not the assets. So that's one of the first considerations. How are we going to structure this sale or purchase? Is it going to be a purchase of business assets, meaning the tangible stuff, the equipment, the goodwill, which is your business name and your client list, the inventory. So the buyer would be buying all of the assets of the company and then starting their business from there. The other way to do it is to do a sale of shares. So the buyer buys the shares of the company and steps into the shoes of the former shareholder and just carries on operating the corporation which owns the business.
What are the advantages as a seller in selling the shares over the assets?
Yes, it's typically in the best interest of the seller, almost in every scenario, to sell the shares of their company because they can typically take advantage of capital gains exemptions for small businesses, small Canadian corporations that own businesses. You would be exempt from capital gains when you sell your shares. So there is a huge tax advantage.
And also, is there another advantage of selling the shares?
From a seller's point of view, it's cleaner. It's definitely cleaner because the buyer will take over both the assets and the liabilities. They step into your shoes and they just assume all of your obligations and all of your assets. The legal documents are certainly a lot more straightforward in a share sale.
And what are the advantages for a buyer of buying the assets?
The advantage for a buyer is that they're not assuming the liabilities. They're buying the assets free and clear of any liens and charges. So they don't assume liabilities like tax liabilities. There's a nice clean break at the time that they take possession of the assets. They don't assume the past tax liabilities of the seller who operated the business before the buyer. Whereas in a share sale, if the buyer steps into the shoes of the seller and assumes their shares, they also assume all the tax liabilities, all the potential litigation liabilities of the corporation.
If I'm thinking about buying a business, should I enter into buying or selling a business? Should we draft a letter of intent?
A letter of intent can be helpful. However, I don't typically recommend getting too involved and too engaged in a letter of intent. A letter of intent, if drafted properly, should be non-binding, first of all. But I find a lot of times buyers and sellers find themselves in the weeds negotiating these very lengthy letters of intent long before any professionals get involved to assist, before the accountants and the lawyers are involved. And they may have worked out terms that are way too detailed and do not make sense from a legal perspective. It's better if you want to get something down in writing so that you hammer out the main points with the other party, to do a very, very simple, what I call term sheet. You set out the very basics. What is the purchase price that we're agreeing on? What's the target closing date for this transaction? Who are the parties involved? What are the main documents that we're going to be exchanging? For example, a share purchase agreement and a non-competition agreement. And then have a simple statement that this is non-binding, that the binding agreement will come once the lawyers get involved and draft the actual share purchase agreement or asset purchase agreement. You just want the very basics, and a very basic term sheet can be helpful for your professionals so that they have some guidance on where to start with their legal agreements. But I often see these letters of intent get very, very long and involved, waste a lot of people's time, and sometimes cause more problems than helping.
So if I'm selling a business and there's a non-competition clause in the business, what does that mean for me afterwards?
So a non-competition clause is your promise that you will not compete with the business you have just sold. You will not compete with the buyer of your business. Typically, we will see a certain period of time set out, like for 2 years after the closing of the transaction. You will not compete with the business. In other words, you won't set up another business down the street that directly competes with your former business's customers.